watch that here.
They're coming back in the courtroom right now.
Yeah.
Those other guys. We're gonna have some real evidentiary jobs.
All rise. Donald Angel, Patrick III, Circuit Court Judge of Raleigh County, is now presiding. You may be seated.
All right, we have taken our break and given counsel an opportunity to review the evidence, and I know that you folks have had a chance to do that. Where are we, please?
We've scratched the surface with the evidence that has been provided to us, and the results of that scratching the surface are disturbing. We have looked at the potential bottles of insulin that nobody can identify where they came from. So now, motion to suppress the bottle of the insulin may have to be postponed because we really have no clue where those bottles came from, along with some other medication that the FBI apparently had, and we had no idea where they came from and what.
Well, you knew that there were bottles. We have talked about that at every hearing.
There was one bottle, Judge.
Maybe one bottle, and
All of a
now they
sudden-
have 3
All
bottles.
of a sudden, the bottles that they tested have materialized out of thin air. I don't know what. And
How many bottles are we dealing with now?
all right, Mr.
At this juncture, a cursory view, there are 2 bottles, 2 vials listed as ID2, where we have no idea where they came from. We had no prior knowledge of these. We have no photographs of them. No information whatsoever as to where they came from or what's in them. We do have an exhibit listed as ID5, which we do have photographs of that, which we believe is the original vial taken from Ms. Cochran's refrigerator.
That was the one behind the carrots.
Allegedly, yes. But we have numerous problems with that now, in that bottle is completely empty. We don't know what happened to the contents, whether they were used up in testing, but that's the only vial that we have a photograph of, and the only notice of a vial taken from the original series.
Okay. Well, our purpose today was to conduct a McGinnis hearing, and I think we can go forward in that regard. I know that there are questions that the defense has in regard to bottles of insulin and other photographs of evidence that have been reviewed, and perhaps we can deal with that on another day. There may be a motion to suppress that we can focus upon down the road, but I think we can accomplish our purpose scheduled for today as planned. Do you agree, Mr. Truman?
I do. Today's hearing, as the state understands it, is the McGinnis hearing. There was a possibility of a suppression hearing. In fairness to the defense, the evidence situation is complicated. While they say they can't account for this missing or found evidence, I don't know that that's fair. Because there were so many law enforcement agencies involved and so many evidence custodians involved, the state is confident we'll be able to demonstrate that. However, the people that can explain it are not available today. And so that you know, the case agents are not here. One is also had surgery. It seems to be that Raleigh County is scourged with ailments today. But he would be my most likely person to explain it. He executed the search. He knows what happened to the evidence in the federal case. He knows what happened to the state case. But that evidence has been to the FBI, some of it, not all of it. It's been at BCI, some of it, not all of it. And it's been at the Troop 6 detachment. So I think these are issues that are not insurmountable, but I don't think that the matter is right for a suppression hearing today on the evidence. The McGinnis hearing, however, is very straightforward. The state's filed a notice requesting that this court take judicial notice of a sealed federal document and its attachments, and even though the state's position is, even though it may look and smell and kind of walk like 404B, it's really not. It's all part of the same case. But we certainly understand that there is an alternative view, and 404B may be appropriate. So that, I think that can be resolved with a fairly straightforward hearing.
All right, I'd like to go forward with the 404B hearing today so we can make some progress. We can continue the motion to suppress to another day and afford counsel an opportunity to review that. What I'd like to do is for you, Mr. Truman, to contact your personnel that can identify these exhibits and this evidence, and I'd like to do it in my jury room so I can keep tabs on you folks and make sure that it gets done in a timely manner.
And I anticipate Trooper Bledsoe coming back to work Monday.
Okay.
He had a procedure on this past Monday, and that was his best estimate was either today or Monday. He's not here, so I take it that he's still recovering.
We can schedule something for a review if you want to, or if you want to contact Trooper Bledsoe and get his schedule, and then let me know something, and then we can schedule it.
And if we can use the court's jury room, I don't know if the defendant has to be present to review the physical evidence. That's another matter that somebody's going to have to take up.
I'd like for her to be present. I think that she should be right there and view the evidence when her counsel sees it.
The state concurs. It would just involve filing a writ and getting the hearing.
Well, not necessarily, because she's right here. She's at the Southern Regional Jail, and we could just bring her right over.
I think isn't she doing? No. Never mind. That problem has been resolved.
All right. Well, I know she's anxious to get back to Hazleton, and I understand the circumstances fully because we had a hearing recently. But maybe we can schedule this for next week, and it won't be too much of a delay.
If that review of the evidence prior to wasting the court's time or scheduling a hearing, I think would be the most efficient way to do it. And for that, we would need at least Trooper Bledsoe and maybe some more people. We can come in and meet in the court's jury room if that's acceptable.
Okay.
And with the defendant present and go over that.
I'll ask the bailiff to have my judicial assistant come in with the book, and let's get a tentative date that's convenient with all the parties. Do this and at least get a head start.
Judge, is there any possibility because of the defense schedule that we can do this on the 20th? That's a week from today.
Sure.
And if not the court's jury room, I'm sure somebody's would be available.
I think that mine will be available, but once I see the calendar, I'll know for sure. Yes, that's a Friday, September the 20th. If you want to wait that long, I can get it in quicker perhaps, but the 20th, my jury room would be available. I've got a full day, but everything would be done in my courtroom, and I won't have to use my jury room. If you can line up your folks, Mr. Truman, and have the evidence brought back here, or have it secured maybe in your office, we can do this. Let me ask the defense counsel if you will be available.
Your Honor, I suggested that because on Monday I'm scheduled to appear in Cochran County for what is now to be 3 jury trials, which of course I cannot do 3 trials at the same time, but nevertheless one may go. So I don't want to schedule something here if I'm in a jury trial.
Okay, when does your potential jury trial start?
Monday.
Monday, the
Your Honor, Friday is the
16th.
Yes, Your Honor. Friday is the best time for, at least for myself. We cannot speak for my co-counsel. Friday would be the best, absolutely the best day.
Okay, so you would be available, even if your trial goes, you think you might be available on the 20th?
I will have to ask the judge for postponement of that trial.
Okay.
If it's
All right, let's shoot for the 20th, and you want to do it at 9 o'clock, 10 o'clock, I can make it convenient for whatever.
let's make it at 10 o'clock, Your Honor.
I thought you would say that.
I-64 obstruction.
Okay, 10 o'clock, and you can have the whole day. My jury room will be available, and you folks can hash it out.
Your Honor, at this juncture, I'd like to, is it all right if I remain seated?
Sure.
We haven't brought it up yet, but we are still fighting for all of the discovery that was supposed to be downloaded by the prosecutor's office. It's still in limbo. We've been trying to get that for 2 months now.
So there's still problems.
Still problems, and once we get it, it's merely an indexing of the information. We have to go through all of that information.
Well, we've got a new prosecutor here, a new sheriff's in town, and maybe we can get rid of
I
some
think
of
that they've been provided everything, except as I understand it, the court's contact with the state police for review of personnel files. Other than that.
And I haven't received anything on that. That's supposed to be done, but I haven't gotten anything yet.
But
Your Honor, I'm talking about all of the laptops, computers, etc., which were transferred and are at the Fusion Center for downloading. We still haven't gotten that, and we haven't gotten a date certain to receive it. That was what was supposed to be done.
And the problem with this, Judge, is that, you know, as we have just witnessed, we have just reviewed some evidence, a sample of what may be in the state's possession, whether it's the FBI, whether it's the Secret Service, whether it's the prosecuting attorney of Raleigh County, or any other agency. We have just been surprised with the material that came out of nowhere. We really want to know what is there in the possession of these all authorities in terms of the materials that we've been looking for since March.
Okay. Mr. Truman, could you confer with Susan and Ms. Acord and maybe see where we are on this?
Yes, sir. Sure thing.
Okay. Right now, maybe you all can huddle up and figure things out.
And Your Honor, I'm sorry, Your Honor. I have some other matters, but I believe we will discuss those out of the courtroom. So.
Okay.
The defense does have, this is a second download. They have the first download. So this is as a courtesy to the defense, it's being done again.
So this is a third download.
Second or third?
Second to my knowledge,
That's
for
it.
the laptops.
Yes.
Well, let's go ahead and do it so that there'll be no further
That's in
questions.
process.
Your Honor, just for clarification, it's not a second download of information we already have. This is additional information that was contained on computers, laptops, other devices that we don't have yet. We only received a download as far as devices of an iPhone and an iPad, which we've been going through. This is things that we have. All of this came about because we made a trip to Charleston to meet with the Secret Service. They had boxes of computers, and laptops, and digital devices on the table there. It was impossible to go through it at that time. Since that time, Mr. Hatfield made a suggestion about a month ago, maybe more now, that they could download all of that information in a special program that would index it so that we could go through it and see if there was any additional evidence we needed to form our case. So we don't have everything. This is not a second download. This is a gathering of information we haven't looked at yet.
Okay, do you all know anything about what Mr. Hatfield promised with this download and index and all that?
This is a second time. They have everything, they're gonna get it exactly the same. All of those devices are downloaded and sent to them on a hard drive.
All right, can you have all of this available on the 20th so that we could work through that on the 20th in the jury room too? I'll be available and I'd like to see what we're talking about because I hear about this every hearing that we schedule and I'd sure like to put it to bed.
Yeah, we will do our best. We'll contact the Fusion Center and see where they stand on the
Okay, let's see if we can get that on the 20th and we will kill two birds with one stone and deal with everything.
And then also, Your Honor, and we can discuss this with the prosecutor's office. We received a thumb drive or flash drive a week or two ago, which has information we cannot access. But we will work with the prosecutor's office to see what they downloaded and what's on it.
Maybe you could bring your laptop on the 20th and we can work out the bugs. Okay, let's proceed with the McGinnis hearing. Mr. Truman, are you prepared to go forward?
Yes, Your Honor. Does the state have it before the request for judicial notice?
I don't have that. I don't believe. I do have it. I've got it right here. I apologize. I do.
Under the rules, this is a very straightforward, those documents were under federal seal, and we asked the court to notice the federal conviction and sentencing and along with all the attachments.
Any objection?
Your Honor, I'm sorry. We filed a 404B exclusion motion that dealt with something completely different. That was noticed for today's hearing. What the prosecution filed, maybe 2 days ago, is exactly what Mr. Truman argued. So I can answer Mr. Truman's argument. I believe that the state does not need to tell the jury that my client was convicted of a crime involving dishonesty that would be unduly prejudicial. The jury may realize that and will learn that from the voir dire, whether they know anything about Natalie Cochran's trials and tribulations in federal court. But the state can very well present the case without the conviction, without her statement at the time of the plea, without her sentencing, and without the federal incarceration.
All right, and that is a matter that we will deal with. What we are focusing on here is a stipulation of facts for this particular hearing. And we're not talking about what would be presented to the jury. The jury's not here now. We're dealing with a McGinnis hearing, a 404B hearing, and the court has reviewed the stipulation of facts from the United States District Court, and it is judgment in a criminal case. I think that it's routine in the sense that the court is generally familiar with the matter at hand, and I'm going to grant the state's request to take judicial notice of the matters attached to the state's motion. Again, this is just for this hearing, and that the court will reserve the right to present limiting instructions, restrictive instructions to counsel or to the jury once we get to trial.
May I reserve my potential objection at trial for the admission?
Oh, certainly. Indeed.
Now, Your Honor, as far as the 404B evidence that we argue should be excluded, I hear from the prosecution that the prosecution does not intend to use it. And that was the evidence of dealing primarily in my motion with the matters of, the defendant's alleged lies and medical records at Duke, etc., etc. That, I believe, the state is not going to seek.
Well, so this is what the court believed, and again, we've switched horses in midstream, and we have a new prosecutor, which is fine, and he can certainly speak for himself, but the two issues that I thought we were going to concentrate on for our purpose here today was the alleged Ponzi scheme and the alleged lies that were made by the defendant concerning her medical condition. Now, if the state does not intend to use one or both of these matters, we're done for today and we can all go home. If the state wishes to go forward on either or both of these matters, then we must have the hearing and the court has to make appropriate findings. And I'll ask Mr. Truman, and we'll start with the alleged Ponzi scheme. Does the state intend to present that in its case before the jury?
We do, and based upon the court's assessment that this is 404B evidence, it would come under with a limiting instruction. From the state's perspective, this was all part and parcel of the same case, but we understand the court's ruling and we'll live with it.
All right, and actually I've ruled that it's potential bad act evidence and not necessarily 404B problems. The court just wants to go forward out of an abundance of precaution because no one knows what will happen at trial. No one knows how the evidence may unfold. And so I thought that it would be wise to at least consider the aspect of bad act evidence, 404B evidence, and deal with it in that manner, with the understanding that the argument has been made by the state that this is part of the res justa, that these things are part of the flow of the defendant's activities. And that may well be that the court hasn't heard the evidence and the court is unsure at this juncture as to what might unfold.
And that's the way the state understood the court's ruling as well.
Okay, the second part, Mr. Truman, was the alleged lies attributed to the defendant concerning her medical condition. Does the state intend to present that matter to the jury?
We do not intend to bring in the doctors and testify that they never said she had the condition that she had. It may come up in other contexts that the defendant said A, and in fact there was no support for A. We're not going to have a whole mini trial on the defendant's lack of truthfulness in terms of calling multiple physicians to say, I never told her that, which at one point made sense to the state, but I don't think we need.
Okay,
so that's it.
To make it
Defense counsel
perfectly
is correct.
To make it perfectly clear that the state will not, in its case in chief, illicit evidence concerning alleged lies made by this defendant concerning having cancer or having some disease or illness which may have not been proven later.
I don't want to deceive anybody. That may come up in various statements because the state is entitled to introduce inconsistent statements by the defendant as she made them. But it's not germane to the heart of the state's case. Whether or not she had cancer is of no moment in terms of liability on a criminal basis in this case.
Okay. I think that's as clear as we can get it, and if it comes up, we'll deal with it, but the state does not intend to present medical evidence, doctors that will disprove statements that the defendant may have made to others. Yes, Mr. Seller.
I think we need to go farther in the ruling in that Natalie Cochran's medical records were never properly subpoenaed or accessed by the prosecutor's office. There were no special orders to gain her medical evidence or history. I believe all of that is off limits. Statements to doctors are protected. It's doctor-patient privilege. Her medical records are privileged, and there should be no introduction of conversations between Natalie Cochran and her doctors or her medical records.
I agree, and I understand the state's not going to raise that. You'd have to have a doctor here to testify in that concern, and they're not going to present any doctors, and there'd be no way that the court would allow it to just pop up.
Thank you for that clarification.
All right, let's go forward then. We're dealing with the so-called and alleged Ponzi scheme, and I'll allow the state to proceed.
Your Honor, I believe that the state's evidence, I don't know that we need a witness since the court took judicial notice of it. That is essentially the Ponzi scheme, the federal conviction and its related matters.
All right.
Let me turn to the defense. Are we at least clear? The court must make some rulings naturally, but does the defense wish to present any evidence? Does the defense wish to object to the manner in which the state has proceeded?
Well, we wish to object, of course, Your Honor. She didn't plead to any Ponzi scheme. She pled to wire fraud, which is in and of itself different type of conviction. I think that the state intends to bring the evidence, and that brings us back to the argument that we have just heard, the evidence of her federal conviction only to inflame the jury against her, to present her as a walking fraud. And that in and of itself is a comment on her character before the trial even begins. So I don't know how the state can justify bringing prejudicial information to the jury, commenting on her character, and trying to justify the conviction as the predicate for the murder. There also has to be a link between this conviction and the alleged murder. How the state can do it, I don't know. But the fact that the state is bringing the prejudicial, highly prejudicial, unduly prejudicial information of my client being a convicted fraudster, and that is going to immediately inflame the jury against him. So,
All right. Chairman, do you wish to respond?
Briefly, Your Honor, it is not a comment on her character. This again is one common plan by the defendant. We will not go into great detail, but the condensed version is that she had scammed a number of people, including the victim in this case. She was about to be discovered, and that was her motivation to kill her. It bought her a little more time. It didn't buy her enough time because she's in a federal penitentiary now. but it's not a common object. This was her plan, this was her design, this was her goal, not to be discovered, and she bought herself a few more days of not being discovered. That's the case.
Without trying this case right now, we have maintained from the very beginning that the state's motive, which of course they don't have to prove to the jury, is absolutely absurd. And to claim that somehow my client was discovered by her late husband in order to silence him or do whatever she planned to do is equally absurd. But if that's the state's theory, so be it. But the state does not need to prove that in order to her late husband to discover her continuing fraud, the state has to prove and demonstrate that she was actually convicted of it, and that's wrong.
She was convicted of wire fraud.
And
Yes.
money laundering.
And money laundering. All right.
Would you be able to have a witness available to testify on the 20th, Mr. Truman?
Oh, I'm sure we could, yes, sir.
Well, I think the court would like to hear some more evidence in view of the circumstances of the defendant's federal conviction. Conviction of money laundering and wire fraud may involve the so-called Ponzi scheme and may not. But I think I'd like to hear some evidence from an investigating officer who can testify as to what involvement the defendant may have had in these so-called scams. The court understands that the state's theory, absurd or not, and the court is willing certainly to allow the state to go forward and present its case. But because there is some differential between a Ponzi scheme overall and conviction of wire fraud and money laundering, the court believes that some additional evidence should be presented, and we'll do that on the 20th. I'm not certain that we do it right at 10 o'clock because, as I say, I have a full day, but we will work it in on the 20th if you can get a witness here, Mr. Truman.
I'm confident we can get a witness here for that.
Okay. That's what we'll do, and then the court can make an appropriate ruling based upon the evidence. All right, what other damage can we do in this matter today?
Nothing from the state, John, thank you.
If we can do more damage to the jury room and keep reviewing the evidence.
Certainly, you're welcome to stay here all day, and even all night if you want to. I won't be here, but you're welcome to stay and go through all of that. Let me say this, I'm intent on going forward on October the 28th as planned. I'm convinced that no matter when we would set this trial, there would be a request for continuance. I was a defense lawyer for 20 years, and I've always wanted to postpone trials. I always felt like I didn't have enough discovery. I always felt like I wasn't prepared enough. And so it wouldn't make any difference whether I'd have this case on the 28th of October or 3 years from now. There'll be some problem and some request. I intend to go forward with the trial on the 28th. I would like to perhaps start on the 22nd and select the jury so that we can have the jury ready and we can start the trial on October the 28th without any fumbling and bumbling. And so I'm alerting counsel that that's the plan, and that's where we will go forward and be in a position to have opening statements at 9 o'clock on October the 28th, 2024.
May we have a brief ex parte with the court concerning representation in this case?
Certainly. All right.
We ask the indulgence of the prosecutor in that regard, but I think this deals with the matters of counsel, well, representation.
Okay.
All right, thank you all. This hearing is concluded.
Can I tell you some kind of diary order for this?
Please.
As long as you get us right, first, it's what we said. If you need, I think, I don't know.
I remember what was on the model.
What was on the model? Just what you said.
There was a label on it. I don't want to put that appropriately, actually, it's human law.
I'll read it from the page. What did you think?
See,
I'll
that's-
take some. Okay, all right. That's
I was using the identifying label.
Yeah,
That's what the identifying label. I think it was an ID number.
That's what you said.
ID, I don't remember which.
That's what you said. B is in board.
IB 5.
Okay. That's what you said.
This is just like some top out of those kinds of statements that we know. Just courtesy copies of, instead of having some.
Okay, you have a copy, Matthew?
I did. Here's a copy for you. It's simply just like the recorded, where they did recorded interviews and statements, typed versions of them.
Oh, the transcripts.
Transcripts.
You're on
They, I got.
big help.
Yeah, that's it.
Transcripts of.
Statement, witness statements.
Oh, yeah.
We didn't know they existed.
I don't know. It's fine.
Yeah. Is that helpful?
Guys were here. And Truman's like. Yeah.
All right.
Right, be in touch.
Do you need help logging?
Logging or logging?
Logging. And then you guys are gonna go back and look at more evidence?
Yeah, we're gonna.
Go back and talk to you.
Please, I'm being very quickly.
Yeah, that's what
Come back and talk to the judge about representation. I may have to-
Okay. All right, let's do it. Quick as possible.
I'll go with Natalie.
Okay. No, I think we have to have an spot with the judge, so. Dennis?